topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
Hey, good afternoon, Orlando, Florida. Welcome to another Ask the Experts radio show, where for the last 17 years we have brought you the finest experts in the field of legal, health, financial, and home improvement. Speaking of 17 years, this law firm, the K. Bender Rimbaum law firm, has literally been with us for 12 years. And we have watched, well, they were growing before they started with us, but they have offices not only in Pompano, Palm Beach, Tampa, and today's show in Orlando. I got to tell you, bring on my friend, first of all, my buddy. This is board certified. I love saying that. Board certified attorney Alan Swartzide, because for the people who don't know, Alan had to go through a lot of extra training to get that board certified. Hi, buddy.
Yeah, I'm very happy to not have to ever do that again. But I appreciate it. It was training as an attorney, but the big part and the biggest pain in the behind, other than filling out the application form, which was also a couple hours worth of work, but taking an exam that's almost like the Florida bar, but specific to this area of law. That was brutal. But I'm glad to have passed on the first try, or no, actually it was the second. But I don't ever have to do that again. I just got to make sure.
Wait a minute, did you spell your last name right?
I did.
Is that what it was?
I did. You know what? I was 6 points off the first time around because I missed the S. I said Alan Swartzide, and it didn't work. No, but Steve, thanks for having me. Thanks for pointing that out. It really is. I mean, I was looking online the other day, and I realized there's less than 200 people in the entire state that have this qualification. So I appreciate it. You know, I know you always like to point it out, and I appreciate that you're so excited about it. I think at this point you're more excited than me about me having this qualification. I genuinely appreciate it.
You're so humble. But hey, Alan, I got to tell you, you know, we do about 30 shows a month, and I always look forward to the last Thursday of the month at 5 o'clock Eastern time, because I know, you know, sometimes you just banter with somebody, and you and I have got this great banter, and I got to tell you, you would not believe all the people who just write in saying how much they enjoy your show, Alan.
Well, I appreciate that. You know, it's nice to have people that appreciate putting the time in. You know, I frankly rather be doing this with you and answering these questions than doing the real work. But, you know, I do appreciate people that take the time to write in and say that they appreciate me taking the time. It means a lot to me.
Yeah, we get probably about 100 questions a month. Now, this is just for Orlando. We do a show for Tampa. We do a show for South Florida. This is just Orlando. And thank God, most of those 100 letters we get are mostly thanking us for the show. So, but, you know, we're on TikTok now. Alan, first of all, I tell people, because there's so many new people now tuning in, tell people about K. Bender Rimbaum.
Sure. So our firm has been around since the 1990s, representing condos and HOAs and co-ops is pretty much all that we do. I also have a mediation practice that runs through the firm along with one of my colleagues, Jeff Rembaum. but we only work on community association issues. 27 attorneys, 9 including myself, as you mentioned, Steve, that are board certified in this area of law, 1 board certified in construction, offices here in Orlando. It's actually Winter Springs, but it's close enough to Orlando that's what people understand. Tampa, Palm Beach Gardens, and Pompanos. So any community in Florida that needs counsel, whether you're unhappy with the person you're working with or the law firm you're working with, or you just need a second opinion, feel free to reach out anytime.
Well, someone took the time on TikTok right away, and I kind of shared this with you already, but no one has ever asked this question before, wanting to know what's the difference between a condo and an apartment.
Yeah, I mean, it's interesting that no one's asked because a lot of people look at it the same way. And even a lot of condominium documents actually call the units apartments. But the reality is the difference between an apartment and a condo, honestly, is ownership. With an apartment, you're renting that thing. With a condo, there's a single owner usually that owns the individual units. In an apartment, it's usually that there's someone that owns the building. Now, the bigger difference is that it's not a declaration of condominium that an apartment complex is going to deal with. There may not be bylaws. There might be articles of incorporation, but only for the corporation that owns that property. So it runs very differently, and it's under a completely separate set of statutes, being a tenant in a residential apartment versus a residential condo. The apartment chapter, the landlord-tenant statute, is a lot shorter for residential than I think it's up to about 180 pages now, the Condominium Act in Florida. So it's physically, you might not see the difference. And that's why a lot of times you have people convert between condo and apartment or in the opposite direction. It's because the building is the same thing. It's just a matter of the ownership and how it gets operated. So good question. That's interesting. I've never been asked that one either.
And so I want to go to our YouTube chat line. I had to do this. Alan is one of the very best. This has got to be a cousin of his. Alan is one of the very best when it comes giving out association board member certification courses. So you teach this course, and it's nice to give feedback like that, right?
It is. Usually it's just, yeah, thanks for the class, and that's it. But I appreciate someone that actually enjoyed it because, frankly, that's the least interesting class that I teach.
Yeah, I'm about to tell you something. I told this to you before. I've actually gone to several of the seminars that Robert and Michael do. I guess it's Ask the Lawyer or the Attorney.
Yeah.
And I got to tell you, Alan, I don't live in a community association. So I thought, well, I love these guys up here. I got to tell you, it was the most interesting. And what I noticed, there was a guy next to me and he said, I'm going to ask my one question and I'm out of here. This guy ended up asking at least 15 questions. So people do have a lot of questions.
Yeah, they do. I mean, frankly, if that wasn't the case, what the hell would we be doing here?
Right. Yeah, exactly.
I mean, I'd love to talk to you for an hour every month, but I don't think anyone else would enjoy listening.
Okay, let me get back to our questions from our listeners. Vern in Orlando, I really enjoy your show. I keep telling my board they should interview your firm. I'm thinking of running for my board. What qualifies for a good board member?
A couple things. I mean, there's nothing statutorily. You got to be a member of the community, and you have to not have certain conditions like you just got out of prison 5 years ago, things like that. You got to pay your assessments. That's to qualify as a board member in general. But to be a good one, you have to listen more than you talk. You have to actually pay attention when your experts are giving you advice. You got to ask for that advice. If you've got a management firm, you got to let them do their job, which means that, yes, the board gets to make the decisions, but you delegate to the management firm and give them direction and let them do the parts of the management of the community that the contract says they're supposed to be doing. There's a reason you're paying them. It's to do the job. The reality is that the biggest thing I think that makes a director a good one is understanding, changing your mindset from the perspective of this is what's fair for everyone. This is what we want to do for everyone. We have to be kind and nice, to realizing that as much of a pain as it might be, as a director of an HOA, a condo, or a co-op, you are running a business. So you need to understand whether you've got business experience or not. Frequently doesn't matter at all, but it's understanding that your decisions need to be business decisions. I think that more than anything else is what dictates whether you're going to be a good director, because being kind to some people or being kind to everyone is actually a detriment a lot of times to the association.
Alan, and I think I tell you this on all those shows. So we get a lot of people who complain about their board. I understand that, those things happen. But these same people, why don't they just run for the board instead of just putting all these complaints out there? Because
I'll tell you why.
Doing this for so long, I see that sometimes it's hard to get board members.
Because it's a lot easier to complain than to change something. And if they get on the board, they have actual responsibilities. If they just complain, then they can hope that someone else does the work for them.
Yeah, that's right.
That's reality. If you are going to complain about the way that the board is running this business and not throw your name in the hat next time that a nomination, an open spot on the board comes up, you're just lazy. Now, you may be too busy to serve on the board. I don't serve on my HOA board. That's just because I'm smart. Because then it would be Alan's the attorney. No, I'm not. I'm on the board. It's hard to separate those two. But the reality is, if you're choosing to sit there and complain, you will frequently hear attorneys, including me and my associates, saying to people, listen, if you're that upset about it, Steve, like you're suggesting, get on the board.
Yeah.
The only way to make the change is from within, or get a petition that the board has to actually, take a meeting and pay attention. But the reality is, sending your individual complaints means that you are one of many who is complaining. And if you are one of, let's say, 550 homeowners, it doesn't mean your voice doesn't matter. It's just that no one else is complaining about this. You are. So the board might presume it's not really something that the members care about, that the association should spend time and money dealing with. But again, I think anyone who chooses not to volunteer is basically saying that I don't care if my complaint falls on deaf ears. Those are the people that'll sue the association instead of fixing the problem.
Alan, one of our obligations to get on TikTok, with certain things we have to do now. One is, please, if you're on TikTok, please share the live, tap the screen. If you like the show, please give us a like. That's all we ask for. We don't ask for any gifts. Let's go to Ben in Orlando. Does K. Bender Rimbaum's advice extend to guiding associations proper, not-for-profit corp regulations and procedures?
Short answer is yes. I mean, Chapter 617, even if you're a for-profit, Chapter 607, we're obligated to know a lot of those laws, and we're obligated to interpret them, including how they interact with the condo, HOA, and co-op statutes. So the short answer is, yeah, absolutely. Now, the longer answer is, it depends what you mean by that. Because if you're sitting here trying to do a $50 million real estate deal as part of running your business of the HOA or the condo, that might be something that we hand off to somebody else. But I would say I've been back with the firm for 4 years as of August. I think there have been 3 times that my office, which currently has roughly 300 clients, has actually said you should probably find a different attorney to work on this particular aspect of what you're working on. And it's really just been, this is a massive real estate deal. That's not really what I do. So make sure that you're covered properly, and we'll handle the association aspect of that. But as to the Not-for-Profit Act and the For-Profit Corporations Act, yeah, these are things we deal with every day.
Let's go to the chat line. When a board member or board of director member goes north, and we don't have a board meeting, how do we get the okay to pay for irrigation repair that needs to be done?
Well, both the condo and HOA statutes say that a director can attend a board meeting by Zoom or by phone. So being up north, unless you're literally in the middle of the wilderness with no phone, and at that point you can still get a satellite phone, that's not really an excuse not to show up for that board meeting. So the way you can do business is have them show up virtually or on the phone. Now, if you're saying that they are refusing, okay, you might want to consider an amendment to your bylaws that says missing X amount of meetings in a row pulls you off the board automatically so that the board can fill that spot with someone who cares enough to show up for these meetings. Finally, if you're sitting here saying, well, we have, a board of 3 and 2 people are up north, so we can't hold meetings, still the same answer. But if you're saying it's a board of 3 and 1 is up north, you still have a majority, meaning you can still conduct business unless your board is composed of 5 people, at which point 2 is not a quorum and you can't conduct business. But if you still have a majority of people willing to show up that are on the board, you can still do the business of the association. It's just that they won't get their vote counted at each one of those meetings that they choose not to attend by phone or virtually.
Back to the chat line, what is required to replace a board of director member that aren't operating as corporate officers but have designated all authority to the CAM, HOA, and condo?
I mean, that's not always the wrong thing to do. I mean, transferring all authority to the CAM is a problem because they're not paid to make decisions. They're paid to handle the business that the board directs them to handle. Unless there's a contract that's different from everyone I've read over the last 16 years in this industry, that most of the time it'll say, we are going to do certain tasks, not completely run the association. If the board is not doing what you think they should be doing, regardless of whether they did anything that's actually wrong or not, pursuing a recall and trying to pull people off the board is really the only option, unless you're going to just wait for the next election and get people to show up and vote in the way that you think they should. So in reality, they might not be doing anything wrong. You might be misinterpreting because the manager might be performing a lot of tasks that are decided on by the board. But if the board is basically just ignoring their obligations altogether, you might consider a recall.
Kathy in Pine Castle, a condo. Condo is a fictitious name procedure. She's got in parentheses published, required for associations to protect name.
I don't know what you mean by a fictitious name procedure. If you mean like a trademark or something like that, there are a lot of communities that choose to do that. Most of them are the branded communities, like Margaritaville communities, and some of the Del Webs, I think, do that. It depends whether you're afraid that someone's going to use your intellectual property. Frankly, it's probably a good idea for every community to get that trademark and be able to fight people that are posting on Facebook and acting as though they represent the association when in fact they don't. But honestly, I've seen this come up in 16 years, maybe 5 times in my practice. So I don't think it's a major issue. It is not a huge investment to get that taken care of. So for some communities, it's probably worth it, but it is not required. What you do need to have, according to Florida law, is your name needs to include the word condominium if you're a condo, and you do need to file articles of incorporation with the state of Florida so that you actually have a corporation to run this community. I mean, you need to have a declaration and bylaws as well, but if you're talking about just creating the name of the organization, it just needs to say condo, and it should be a corporation, and it needs to be filed with the state. Should be a not-for-profit. Some are for-profit corporations.
Back in the chat line, this is Deborah. What about an HOA that conducts a side venture such as an occasional community market to fund small committee expenses? Any problem with that? Detractors are saying we can't, as we are a nonprofit.
Well, there's a big difference between having a profit and generating money that gets spent. Profit is not you brought money in. So I'm going to ignore the question to some extent and just talk back to the detractors and say that's not profit. If the committees that were mentioned are using the funds, it's not left over at the end of the year. It's not going in an individual's pocket. It's being used for association expenses. It's just that it doesn't come out of everyone's pocket. It comes out of these specific funds. Now, my concern, now that I've answered the question, is talk to your insurance company about what liability you might have if during these functions that are not technically association functions, someone gets injured, someone gets sick, etc. So it's more of a liability concern than that it's considered a profit. People misunderstand profit a lot. It's not that you had money left over at the end of the year. It's that you're giving that money out to individuals or corporations. If you're just using it for association purposes, even if it's for some committee of the association, that's not a problem, in my opinion. Or more accurately, that's not a profit, in my opinion. But you might also want to talk about your CPA.
Is there any reason, we just lost our question, is there any reason the board could not conduct a non-binding online survey of the owners? Since this would be a survey rather than an official vote, I assume a quorum would not be required.
I mean, yes, the board can conduct a survey, but it would have no legal significance is the issue. A survey is not a vote. It's just questioning, and I don't know what the issue is that they'd be surveying about. If it's a board issue that the board gets to vote on, the board can still vote against everything, even if you had every single member other than the people on the board filling out that survey and saying one answer. The board could technically, without breaching any kind of obligations, vote the opposite. Now, that's the same problem we have with some politicians. But the reality is there's nothing that prohibits the board or the members from voting against what is on any survey. And in reality, I'm not aware of any requirement that the board even consider that kind of survey or consider having one. It might be helpful if the board is just completely unclear on what the members want, but it's just not something that's necessary, in my opinion. I'd rather see a town hall style meeting where the members get to voice their opinions and then the board decides whatever they want to decide.
Okay. What is the opinion of designating a suite number at a clubhouse rather than the main address for leased space to a vendor or for our restaurant or footprint purposes?
It depends what you want to accomplish. I mean, I don't have a problem with it either way, whether you're designating the entire space or you're designating a specific suite number. The real question is, what are you actually renting out? Is it the entire clubhouse, in which event the clubhouse is an appropriate address? Or are you renting space within the clubhouse? Like I have a community in Brevard County that has a restaurant, but the same clubhouse also has a gym and a couple other facilities. I wouldn't want the lease for that restaurant to say that they're leasing the entire clubhouse, because that wouldn't be accurate. And at that point, if that lease says they're renting the clubhouse, technically they have free reign of the clubhouse. And technically, if the lease says they can keep people out, they could tell your members you're not allowed to use the clubhouse because I've leased it and I don't want you to. We can only use the entire clubhouse, including the gym, including the pool that's adjacent to the clubhouse, for the restaurant. So that's where it matters. What are you actually renting out?
You know, I tell you this all the time. One of the great things that K. Bender Rimbaum does is they educate people at free of charge. You are always doing seminars, and you've got a busy month coming up. Can you give us what you have going on for the month of July?
Honestly, it's my partner, Kirsten Henza, that has the busy month coming up. She's doing HOA meetings, notices, and elections on actually tomorrow. I am stepping in and actually doing a class instead of it all being her on Monday. That'll be the legal update, probably the last one we'll do for this year, because technically as of July 1st, you got new laws coming in. So that's the
Yes.
legal update for all the laws that changed last year in 2025. It's the 2026 class, but it's for the 2025 statutes. Understand also, no idea what the heck we're going to teach because nothing really changed this year. So I don't know what we're teaching next year. But Kirsten also has on July 8th that same HOA meetings class. July 16th, updating your governing documents. That's in person in Sarasota. So for those of you that are local to Orlando area but still want to take a drive, have at it. July 17th, we've got a condo board member certification class. July 21st, HOA record keeping and records access. July 29th, HOA financial literacy and transparency. And then finally, July 30th, elections for community associations. Some of these are specific to HOAs. Some of these are for everyone. Some of them are for CAMs. Some of them are, well, no, they're all for CAMs. But, the thing to keep in mind is we're probably going to add a couple more classes next month, because I just sent an email before today, before we jumped on this show, about setting up another class. I don't know what elective I'll be teaching, but it won't be one of these. So that is the reality. We've got a lot coming up, and Kirsten is doing a great job of making sure, as you mentioned, that all of our people are educated, and hopefully they're actually taking these classes and listening, so that the boards that we represent, and frankly, even the ones we don't represent, are a little bit better educated. And we do find that extremely important, which is part of why we love doing the show with you, Steve.
It's always buttering me up. We're going to go to a break. We come back. We have more with our K. Bender Rimbaum, board certified Alan Swartzide. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
Back. This is the last Thursday of the month. We come on at 5 o'clock Eastern time. I just call it the K. Bender Rimbaum Hour. We have attorney Alan Swartzide with us, and we take your questions that you've sent in over the month. And we, as you can see, we've taken in a lot of YouTube questions. We're getting a lot of questions coming in from TikTok. Let me get back to our questions. Randy in Winter Park. How do you respond to the Florida State Attorney's chastisement of the traditions HOA's attempted ban of weapons from common areas? I know every time I ask for opinions on legalities, I get nothing. We're starting to get a lot of those questions with the open, gun laws we have now.
Yeah, I mean, first of all, how do I respond to it? Well, it wasn't sent to me, so I don't respond. But the answer to the implied question is, I think it is poorly considered is the way that I'll put it. I think that the Attorney General wanted to reach a result, and he had legal means to reach that result, but relied on case law and information that really, I think if a judge were to really consider it, probably would not have succeeded. I don't think, to put it in plain English, that the case law that was cited in this demand letter that was sent to the Tradition HOA is actually applicable to a community association, because it's explicitly a completely different situation that was contemplated in the cases that were cited and the situations that were cited. But bottom line, I do think that the associations have the authority to protect the people in their communities. My concern is, listen, I get open carry is allowed in Florida. The reality, though, is that this is not government telling you you can't have it. This is a private entity. And just like walking into, Buffalo Wild Wings and sitting there with an open carry pistol on your hip, they can kick you out. The association, in my opinion, is allowed to do the same thing. Now, concealed carry is a very different situation. If I'm walking around with that pistol in front or on my hip or wherever I'm carrying it, no one should know. So it really shouldn't matter that there's a rule or not, unless you're walking around with a metal detector wand, checking every single person that walks past, which, by the way, is almost what you're obligated to do if you're going to try and regulate concealed carry in the community, in the common areas. I don't really see how you enforce this. The other thing is, are you really going to risk, frankly, a gunfight by fighting with someone about this? Or are you just going to report to the police, who will then do their own thing and probably say there's nothing illegal about it? I agree with the outcome. I don't agree with the way that it was done. And I don't agree with the Attorney General, who really has no dog in that fight, sending a threatening letter to a community association. I'm not really sure where that comes from. I get that it's the Attorney General that would be fighting it if it reached a court. I just don't understand why, other than politics, why the Attorney General stepped in this particular instance.
Hey, Tracy in Winter Park, what's the liability of the association president of a condo association gets a key to access everyone's unit without anyone knowing?
I don't know how they got the key without anyone knowing. You presumably all gave that key to either the manager or one of the directors when you moved in. Otherwise, unless they're changing every single lock in the condo, I don't really see how the president got it. So to say that it was without anyone's knowledge, maybe the president took copies of things that were authorized. I'm not sure what that would look like. What's the liability? It depends what the president does with it. And in reality, most of that liability would be on the president and not the association. If the president goes and walks into your unit while he knows you're away or she knows you're away and steals a bunch of stuff from your unit, that's a criminal act. Generally, the association is not responsible for it. But if the association knows the president has these keys and isn't supposed to, they might have the obligation to act, or they might be implicated as well if someone does have a problem as a result of this person having keys. But the association having access to your unit, if it's a condo in Florida, there's a statutory right of access. So it's not a problem on my end for the association to have those keys. If it's, the president keeping them in an unsafe location in his or her unit, yeah, okay, maybe you end up with break-ins or something like that aren't really break-ins because someone had the key. I just don't see the major issue here. The association's supposed to be able to access the units. It shouldn't be the president acting unilaterally, but it should be the president if directed by the board.
Larry in Lockhart wants to know, we have more people complaining about people smoking pot in their own unit, and it's permeating through to the neighbors. Do the neighbors have any recourse?
Yeah, that could be considered a nuisance, especially if you've got a prohibition against smoking in units in your declaration, which frankly, in my opinion, is probably what you need to have in order to enforce this. But keep in mind, unit owners have the exact same right to enforce the declaration as the association does. The problem is most people aren't willing to spend the money to protect their own rights and expect everyone else to pay for that violation so that they're individually benefited by everyone else paying the attorneys to take care of the situation. So the reality is you have just as much right to go after this person as an individual unit owner as the association or any other unit owner would. So if you think it's such a big deal, take care of it. Go after them the same way we would.
Here's a question that comes up a lot. This is from Billy in Orlando. Is there a limit to the number of ESAs a unit is allowed?
So the short answer is absolutely not. The limit is what they can get a physician to reasonably state they need to serve their disability and provide them equal use of the premises. So if they need 8 dogs in a condo unit, you're required to allow those 8 dogs in a condo unit as long as they can document it properly. Now, what they're not allowed to do is cause an actual problem in the community. You can still enforce the nuisance. It's just that you can't enforce the pet restriction that you might have if that pet happens to be an ESA, because at the point that they're an emotional support or some other support animal or a service animal, they're no longer considered a pet. So if you've got a no pet provision, those animals don't even count toward it. So the bottom line is, unless the number of animals creates a separate issue, as long as they can document that they're supposed to have them, you can't say no. Or you can say no and get in a lot of financial trouble is the better answer.
We're here with attorney Alan Swartzide. This is the K. Bender Rimbaum law firm. We're talking about community association law. For those of you who are watching on TikTok, please, if you would, share the show with your friends. Give us a like. We don't ask for any gifts at all. We're here answering questions that come up during the month. We're really targeting the Orlando area, but K. Bender Rimbaum has offices in South Florida, Palm Beach Gardens, Tampa, and our show we're doing today in Orlando. Jenna in Orlando wants to know, is it okay for a president to create a code of conduct for the board?
Create it, yes. Adopt it unilaterally, no. The board gets to vote on that. That is the new policies that are created for the association are a board decision. So unless the board has already said and voted and delegated the authority to create that policy to the president, that policy has zero effect until it's voted on by the board.
Okay. Just so tuning in, no, I am not an attorney. Alan is the expert here. So I ask questions that you've written in, and I ask them exactly. I don't ever want to put any words, change anything. So I ask exactly the way you write to us. So I apologize if maybe sometimes they don't make sense, but we want to read them exactly the way you write them to us. Let me go to Craig in Forest City. He wants to know, what if the board of directors terms have all expired, no member quorum achieved? What then?
Board rolls over. The people that were on the board are still on the board.
That's easy. This is Phil in Orlando wants to know, and we're starting to get a lot of questions about this. Does the electronic camera have to have signage that their voice and video are being recorded?
So you should have signage for any cameras, especially for voice. You're not in a place where you do have what's called a reasonable expectation of privacy. If you're not in that location, then technically I've seen some cases that say you don't really need to have signage. My opinion is always, listen, if you're going to be recording people, you should have that signage, even if for no other reason than to clarify, is this recording 24/7? Is it being watched and listened to 24/7? because otherwise you might be creating an unreasonable expectation that there's someone sitting in a room somewhere watching the electronic video and that they're going to be essentially protecting the people in your community. If that's not the case, you want to make it sure we're not taking on that responsibility. This is only for purposes of, we keep it for a little while, and if there's an incident reported, we can refer back to the video. So short answer is not absolutely required, but recommended anyway.
Okay. Barb in Orlando wants to know, what are the rules?
Steve, I lost you on that one. What are the rules? What
are the rules if you decide to have a Zoom meeting?
Well, that depends if you're in an HOA or a condo, because they're very different. In an HOA, you have your Zoom meeting, you notice it that way, congratulations, that's it. In a condo, you're now required to record that meeting and keep at least the link to the recording in your official records for 1 year. When we're talking about recording the annual meetings, if you're going to hold your annual meeting virtually in a condo, you also need to have a majority of the board of directors present in person in order to hold that meeting, according to the laws that came about in 2025. And this is why people need to take the class that I'm teaching Monday. But the laws in a condo are fairly different from the ones in an HOA because of changes that came about just this past year in July of 25. But in an HOA, congrats. You got an HOA, a Zoom meeting. In a condo, there are very specific laws you need to follow.
Greg in Orlando, this is a condo, and please, when you write your questions, please make sure you let us know if you are a condo or an HOA. If there is no bylaw establishing a timeline when a visitor becomes a resident, triggering an application and approval to live in a condo, what determines change of status?
Nothing does. If your bylaws, your declaration, your covenants don't say anything about it, that status never changes. I've got plenty of communities where owners are arguing, oh no, that's just someone visiting me, but they happen to have been visiting for the last 6 months. And because the declaration, the covenants of the community, the bylaws, nothing states that the association has the ability to convert that person into a resident, a tenant, whatever you want to call it, for purposes of filling out an application, they're kind of stuck with it. Now, you might want to talk to your attorney about just adopting a rule, even though that's not in the declaration or bylaws, where you wouldn't be able to reject a prospective tenant or a current tenant or resident, but at least you'd have the ability to know who's living in your community. So you can require as a rule that people actually fill out these applications, etc., or give you their information. You just wouldn't be able to say, based on what we found in our background check, you're not allowed to live here.
Peter in Orlando, so let me go to Jordan in Orlando. What can a board do to entice those recently elected to be an officer? We've had several elected members who want to be on the board, but not an officer. This leaves us short of the officers in the future.
Honestly, get a community association manager, because they're going to do 99% of the job of what the officers would otherwise be doing. Pay a CAM to do the job that the officers would otherwise be responsible for. You got no one that wants to be secretary. Your manager will take care of all the bookkeeping. Your manager will take care of all the meeting minutes being prepared. There are certain things that person would still need to be the one to sign, but a manager will take care of most of that. Same with the treasurer. All the dollars bookkeeping, sending out assessment notices and notices of past due balances, all of the money, manager takes care of that too. So if you're not, it's kind of crazy to me, frankly, that you can get people on the board, but they're not willing to serve as an officer of the association, because they're already showing up to the board meetings, and the obligations of an officer, although they may be significantly more on paper, in practice, you're already doing the job if you're showing up to board meetings. So it's not a huge additional imposition of time or responsibility, especially if you've got a CAM. But I think hiring a manager is probably step one to basically saying, listen, this is legally your responsibility, but practically speaking, you've delegated that to the manager.
Kenny in Orlando, our board never misses your show. Thank you so much for educating us. What percentage of disputes are settled instead of going to litigation?
So first of all, I want to say thanks to everyone who's pointed out that they never miss one of our shows. I really appreciate that. The kind words are very much, they boost the non-existent ego a little bit more. So thank you. Now, as to the actual question, Steve, can you repeat it? Because I want to make sure that I'm fully getting it right. Skip the niceties.
They're asking basically, what are the percentages of the disputes you settle? Are they that actually go to litigation?
Okay, before litigation. So the percentage is really high. The reality is most communities will send 1, 2, or 3 notices, and 75% of the time, the dispute is resolved at that point. That's usually for violations. Collection, you send your notice of late assessment. Most people will pay after that. Some people can't afford it. Some people don't want to do what they need to do within a certain amount of time. And so I always say, if you can reach a settlement, it's always going to be easier to get someone to sign a document that says, yes, I'm responsible, than to try and prove it in court. So that is one way that often you'll actually be able to resolve these things without the person taking care of it today. Because that's the thing. People on the boards that we deal with don't always understand. It doesn't need to be resolved today to be resolved without you incurring further attorney's fees and spending more money on lawyers. Okay. The other thing that I'll point out, when you're talking about covenant enforcement, you're talking about, someone did something wrong, whether it's a contractor or a member or a resident or a visitor. I'd say after my first letter gets sent out, most of the time, I'd say probably 30 to 40% of the time that I send a letter, that violation is cured before we go to the next step. So we're left with maybe 5 to 10% of times where we actually need to take it to litigation. And often, especially in a condo or HOA, we send this offer for pre-suit mediation, which is required for a lot of types of litigation now in Florida. And often we'll go to mediation and we'll settle there. So that reduces the percentage down even more. So again, I think it's probably close to 5% to 10% of the disputes that the association initiates or initially gets involved in that actually make it to litigation. And when I say litigation, I don't necessarily mean trial. That's what other people also don't understand. There's this thing called a motion for summary judgment. And after the parties have filed what they need to file, you can get out of a case sometimes without going to trial. And trial preparation, taking depositions, things like that, it's not necessary in most cases. So what you see on suits, for example, is not what happens most of the time in our daily practice, even in the litigation department within our firm. It's mostly just going back and forth with paperwork and hoping that the judge agrees and then arguing in court. But I've had hearings that took less than 5 minutes. It's not always going into court and sitting there for a 4-day trial on whether or not someone needs to mow their lawn. It doesn't work that way, generally speaking. So that, I think it's a long-winded answer, but it's the answer.
Just a little behind the scenes. We have probably enough questions from between TikTok and YouTube and our chat line. We could do another 2 hours worth of shows. Alan, tell people how they can reach your office.
Sure. Well, for email, the easiest way to reach me is email, because no matter where I'm at, I can see it maybe, but I can definitely respond when I'm available. It's Alan Schwartzide at kbrlegal.com, K Bender Rembom. If you want to call us, that's toll free 1-800-974-0680. If you're happy with your attorney, great. If you're not happy or you need a second opinion, hopefully after hearing what we have to say today, you'll consider us.
That's going to do it for us today. I can't wait till next month, Alan, the last Thursday of the month, 5 o'clock Eastern time.
Looking forward to it, buddy.
We'll do it again. Thanks, Alan.
Thank you, and thank everyone for listening.
That's attorney, board certified attorney, Alan Swartzide, K. Bender Rimbaum. Folks, they'll probably hate if I say that, but they're like one of the largest law firms who concentrates on community association in the state of Florida. Hey, that's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.